Hearing in the appeal MS Pakistan against Secretary of State for the Home Department.
Just to remind everybody that we did make an anonymity order in the preliminary hearing that we had in this case. Not that I think there's any risk of anybody inadvertently breaching it, but I always remind people of it at the start of each hearing, just in case. So, thank you, Mr. Coffey.
Thank you, my lady. In this appeal, I appear with Mr. Butler of the Equality and Human Rights Commission. Sir James Eadie and Ms Smythe appear for the Secretary of State. Mr Jaffe appears for the Air Centre intervening, and Mr Hussain appears for ECPAT intervening. The Commission is grateful to the Court for the opportunity to intervene in this important appeal. It is an important appeal because it represents the first opportunity which this Court has had to consider the significance for immigration law of the UK's obligations in respect of human trafficking under Article 4 of the European Convention on Human Rights and the 2005 Council of Europe Anti-Trafficking Convention.
That is, of course, correct, Mr. Coffey, but the main concern that we had when giving permission to appeal was over the fact-finding jurisdiction of the upper tribunal in this particular case, which point appears to be now conceded by the Secretary of State. And so, in one sense, the case gives you an opportunity to introduce the wider issues, but they're arising in a mildly academic context,
yes,
which may inhibit us from doing everything that the parties might want us to do.
Indeed. Well, I was about to say, at the stage...
I'm saying that for the benefit of everybody.
At the stage when permission to appeal was granted, the appeal was important for the different reason which you've identified, that this Court would have the opportunity to reverse what we submit was a seriously retrograde judgment of the Court of Appeal, which had been widely interpreted as restricting the fact-finding jurisdiction of the first-tier tribunal and the upper tribunal in human trafficking cases, including cases under the Human Rights Act. Now, of course, as you say, my lady, the Secretary of State accepts that that important finding of the Court of Appeal, upholding submissions made on behalf of the Secretary of State in that case, cannot be defended. So it is therefore common ground that the upper tribunal was entitled, indeed was required, to decide for itself whether MS was a victim of trafficking, since this was relevant to the issues under Article 4, which were raised by his appeal. The Commission would respectfully invite the Supreme Court on this issue to invite the analysis set out at Section D of its printed case from MS 2316 onwards.
Sorry, give me that reference again, please.
2316,
2316.
my lord. And we would particularly emphasise paragraph 63 of our case on this point, which you will find at 2320, where we emphasise that the tribunal should give such weight as it considers appropriate to the evidence and the reasoning set out in any previous decision of the competent authority, the Secretary of State, on the trafficking issue. The evidence recorded in such a decision may be material, and the reasoning set out in such a decision may be persuasive. But to be clear, no weight should be attached to the mere fact that the competent authority has decided the trafficking issue one way or the other. In other words, and to quote from a case which you now have in the second supplementary volume of authorities, I'll just give you the reference. It's a case called PM, and it's tab 70 in the second supplementary bundle. It's paragraph 83 at MS 3010, the subsequent decision maker, here the first tier tribunal must respect not the finding made by an earlier decision maker per se, but the earlier decision-making process. And that's a neat way, we say, of encapsulating the point.
Can I just check, is the position exactly the same, whether the decision maker has said has been trafficked or has not been trafficked? Because you said
yes.
The mere fact that they've decided one way or the other.
Well, maybe logically it ought to be the same. I can see that it's in practice there are far less likely to be challenges to a decision that a person has been trafficked, but logically it must be right that the tribunal is to decide for itself whether the individual has been trafficked and therefore may have Article 4 obligations owed to him. So that's the common ground as to the error made by the Court of Appeal. The Secretary of State maintains that notwithstanding its erroneous reasoning, the Court of Appeal nevertheless reached the right conclusion in allowing the Secretary of State appeal because, firstly, the Secretary of State argues the decision to remove MS, which was the decision under appeal, entailed no conceivable breach of Article 4 of the Convention because, it is argued, MS was not at risk of re-trafficking if he were to return to Pakistan. Therefore, the Secretary of State says the Court of Appeal was right to rule against MS on his human rights appeal. Secondly, the Secretary of State argues that the decisions which he made through the competent authority that there were no reasonable grounds to believe that MS was a victim of trafficking contained no public law error. And that is said by the Secretary of State to be a matter of common ground between parties. Hence, it is argued, the decision to remove MS could not be challenged on the not in accordance with the law grounds either. The Secretary of State also submits, third point, and this is, we say, the real nub of the case which remains for this court to decide.
Before you mention that, could I just ask, the fact that the decision was not in accordance with the law is no longer a ground of appeal to the immigration appellate authorities, but would it be the case, may not be within your knowledge, but it will be within the Secretary of State's knowledge, no doubt, that there are still many, many pre-change in the law appeals outstanding or as yet unresolved, to which not in accordance with the law is still a relevant criterion?
Yes. Lady, our position is we don't know. I haven't thought about that. We don't know. The law was changed in October 2014. No. It would be nice to think that there weren't that many, if any, cases outstanding, but I simply don't know. It may be that others have a better idea.
Well, the reason I'm asking now is so that the people who ought to know the answer to that can think about it.
Thank you. So
Sorry, you were getting on to the third contention.
The third plank of the Secretary of State's case before you today, which we say is the real nub of the case, which remains for the court to decide. Sir James argues that the state's obligations under Article 4 ECHR in trafficking cases are restricted to the terms of the judgment of the Court of Human Rights in the Rantsev and Cyprus case and cannot be enlarged by reference to the Anti-Trafficking Convention. That convention is said to be relevant only in defining the ambit of human trafficking, what is meant by human trafficking, which is then the target of the Article 4 obligations identified in Rantsev. But it is said the Anti-Trafficking Convention has no further significance. That submission was accepted by the Court of Appeal in this case, paragraphs 85 to 86, in reliance on the previous Court of Appeal decision in Huang and Min. And it also has potentially wide implications. Now, our case in summary on those 3 points is as follows. First of all, we say that the upper tribunal correctly held that the decision to remove MS was a breach of the Article 4 investigative obligation because it would inevitably prevent any effective investigation and prosecution of the potentially serious human trafficking offences which occurred in this case. Secondly,
can I just be clear, that submission doesn't depend upon the outcome of what you describe as the big ongoing issue.
Yes. Secondly, the upper tribunal, we say, correctly identified a number of public law errors in the competent authorities' decision-making. So I'm afraid there is no common ground here, and I would have hoped that was clear from our printed case. Those public law errors were material to the removal decision, and therefore, we will argue the removal decision was not in accordance with the law as a result. Thirdly, we submit that the Secretary of State's approach to the Anti-Trafficking Convention is far too narrow. That convention, we say, is of critical importance in ascertaining the extent of the UK's positive obligations under Article 4 and of what must be done to implement those obligations. Now, I'm going to make my submissions to address those 3 issues between the parties in 3 parts. I'm firstly going to address, in more general terms, the relationship between Article 4 of the Convention and the Anti-Trafficking Convention. Secondly, I'm going to address the application of Article 4 and the Anti-Trafficking Convention in this case. And thirdly, I'm going to deal with the not in accordance with the law ground. First of all, then, the relationship between Article 4 ECHR and the Anti-Trafficking Convention. And just to set out the legal background in a little more detail, you have in Bundle 1, Tab 10 at MS 257 the decision of the Strasbourg Court in J and Austria. And I'll come back to the judgment of the principal judgment of the court in that case. For present purposes, I want to refer, in fact, that's the page reference I gave you, to the concurring opinion, which begins at MS 257, from which we quoted in our printed case paragraph 60 at MS 293, and the part of the conclusion of the judge just delivering the separate opinion, as with the fight against slavery and the slave trade during the early 20th century, the fight against forced labour and trafficking for that purpose has been at the top of the international human rights agenda since the turn.
I'm sorry, where are you reading from?
I'm reading from paragraph 60 on MS 293. I'm sorry, am I...
293, so from the report?
Yes, MS 293, paragraph 60. It's in the...
Page 69.
I'm sorry, page 69 of the report. Thank you. Do you have that?
No, the MS number is what I...
MS 293.
Paragraph 60.
And that is the headline conclusion drawn from the exposition, which I respectfully commend to you, from paragraph 2 onwards, beginning on page 258. There is what we say is a magisterial exposition of the development of international law in this field from paragraph 2 onwards, taking one through and including the United Nations Palermo Protocol and the Anti-Trafficking Convention of the Council of Europe, and referring then at paragraph 40 on MS 284 to the positive obligations which have been developed under Article 4 of the ECHR. I commend that exposition to the court. So far as then the interaction between international law, the Anti-Trafficking Convention, and domestic law is concerned, I would also respectfully commend to the court the careful and comprehensive account of the relevant legal framework, both domestic and international, relating to the treatment of victims and potential victims of trafficking in the TDT case in the Court of Appeal, Bundle 1, Tab 6, from paragraph 6 onwards, MS 124, and convenient, if I could ask the court to turn that up. It's convenient just to take certain basic propositions in relation to Article 4 of the Convention from TDT, beginning at paragraph 13 on MS 126. You have the text of Article 4 in paragraph 13. And you have an account of how Article 4 has been developed in the Rantsev case and subsequently.
Could I just ask you, Mr. Coppell, about the ECAT? Am I right in thinking that it's a Council of Europe convention that all members of the Council of Europe are parties?
Not all members, almost all members of the Council of Europe, as I understand, are parties. I'd looked at this for the purpose of ascertaining whether Russia was a party, and it isn't. And that
Quite
helps
right.
understand the greater reliance upon the UN instrument in the Rantsev case than on the Anti-Trafficking Convention. But I think it's right to say that almost all Council of Europe members are.
Thank you.
Can I, having again just simply commended the account that one finds in the TDT case, can I take you to the Anti-Trafficking Convention then, which is at Bundle 1, Tab 13, MS 410. And I just wanted to show you some of the key provisions briefly of the ATC. MS 412, we have the definition of trafficking in Article 4, which, as we'll see, is adopted for the purposes of Article 4 of the Convention in Sev. You have Article 5, the obligation to take measures to establish or strengthen national coordination between various bodies responsible for preventing and combating trafficking in human beings.
Article 4 is very important because obviously it's the definition, but there are three elements in the definition: the recruitment, transportation, transfer, harbouring or receipt. That's the first element. There's the means, the threat or use of force or other forms of coercion, of abduction, fraud or deception, of the abuse of power of a position of vulnerability, or the giving or receiving of payments or benefits to achieve the consent of a person having control, blah, blah, blah. And thirdly, for the purpose of exploitation. And then there's a definition of exploitation. But a very important part of the definition is that the second element doesn't apply to children.
Yes. So yes.
The transport, or the recruitment or transport for the purpose of exploitation is all you need to show for children, which point may not be entirely clear for those making decisions under the national referral mechanism.
Indeed.
Sorry,
yes,
I just thought it was important
that is right. And in the present case, of course, MS was a child
when
he arrived in the UK. As it happens, the competent authority decided that he had been brought here by deception, so there were means in any event. But yes, you're quite right. It can often escape attention that the definition is different for children. So other key provisions, Article 10 on identification of the victims, MS 414, and we'll see in due course references to the Article 10.1 duty to provide the competent authorities with persons who are trained and qualified in preventing and combating trafficking in human beings, etc. And Article 10.2, the taking of measures to identify victims, and each party shall ensure that if the competent authorities have reasonable grounds to believe that a person has been victim of trafficking, that person shall not be removed from its territory until the identification process as a victim of an offence has been completed. And shall likewise, final part, shall likewise ensure that the person receives the assistance provided for in Article 12, paragraphs 1 and 2. So if there are reasonable grounds, the Article 12 assistance obligation applies. Going over the page then, Article 12, you see the list of assistance to victims that ought to be provided in Article 12.1 as necessary to assist victims in their physical, psychological and social recovery. And 12.2 taking due account of the victim's safety and protection needs. Article 13, MS 416, recovery and reflection period of at least 30 days and at least 45 in the UK, where there are reasonable grounds to believe that the person concerned is a victim. And the purpose of that is to enable the individual to recover and escape the influence of traffickers, first of all, and secondly, to take an informed decision on cooperating with the competent authorities. And 13.2, during this period, Article 12, of course, applies. And Article 14 is a key provision. Each party shall issue a renewable residence permit to victims in one or other of the two following situations, or both. Firstly, where the competent authority considers their stay is necessary owing to their personal situation. And secondly, and by way of reinforcement, as it were, of the Article 4 obligation which we say arose in the present case, the competent authority considers that their stay is necessary for the purpose of their cooperation with competent authorities in investigation or criminal proceedings. Other key provisions, Article 23.1 is the obligation to prosecute and punish criminal offences, and Article 40, which one has on MS 425, relationship with other international instruments. The Secretary of State argues, and I think with particular reference to Article 40, subparagraph 4, nothing in this convention shall affect the rights, obligations and responsibilities of states and individuals under international law, and then specific reference to the Geneva Convention and so forth. The Secretary of State relies on that, paragraph 43 of his case, to argue that this means that the ATC can't influence the scope of Article 4 obligations, because here's a specific provision keeping it, as it were, in isolation, I think is the submission. We say that's incorrect. All that Article 40 is doing is ensuring that the obligations in the Anti-Trafficking Convention are not cut back by reference to other international instruments, and we say that is made clear in the explanatory the explanatory report from MS 484 onwards. Sorry, Article. Yes. 40 sub 1, this convention shall not affect the rights and obligations derived from other international instruments to which parties to the present convention are parties. Same. And which contain provisions on matters governed by the convention and which ensure greater protection and assistance for victims of trafficking. Yes, thank you. So that's the that helps in the doesn't cut down. Or can't cut down the ATC with reference to other international instruments.
Are you going to take us to the explanatory notes, Mr. Cobb?
So the explanatory note of MS 484 there's a section from paragraph 372 onwards. And it's paragraph 373 we rely on, which refers to 40 subpara 1, and 377, which refers to 40 subpara 4. Now, this convention, the Anti-Trafficking Convention, has a status in domestic law which is stronger than most other international treaties to which the UK is a party. It has significantly greater domestic legal force, and that is because the Secretary of State has consistently accepted that the competent authority should comply with the Anti-Trafficking Convention. Can I take you to Bundle 2, Tab 30, MS 848, the Atamuan case. And within that case, paragraph 55, MS 864.
Sorry, I missed the reference.
Paragraph 55, MS 864.
I'm sorry, can you give the tab again, please?
It's tab 30. Tab 30 of Bundle 2. Paragraph 55.
Thank you.
Where you see from the second sentence onwards, Mr. Eady accepted, Mr. Eady as he then was, accepted, at least in this court, that although the Anti-Trafficking Convention had not been transposed into domestic law by legislation, and so did not have direct effect insofar as the guidance purported to give effect to the terms of the CAT and failed to do so, that would be a justiciable error of law. He also accepted that to the extent that the NRM decision was itself based on the terms of the guidance, if they were in turn based on an erroneous interpretation of the CAT, then the NRM decision could be challenged by judicial review, because that decision would then have been based on a misdirection as to the legal basis for the relevant wording of the guidance. And that position has been repeated, not just in the Divisional Court, but also in the Court of Appeal. And just to give you a reference to that, it's PK, Bundle 2, tab 27, paragraph 34 on MS 810. For the same position taken in the Court of Appeal. So practically, if not formally, the ATC is given effect in domestic law through that mechanism. Can I then take you to the key Strasbourg authorities, starting with the Rantsev case, Bundle 1, tab 11, and what we are looking for, as I go through the three East Strasbourg authorities, what we're looking for is assistance on the relationship between the Anti-Trafficking Convention and Article 4. And it particularly is Sir James Eadie right to say that it's simply relevant for definitional purposes and not otherwise. Rantsev, tab 11, as the court will know, is the tragic case of MS295, sorry. The tragic case of a young Russian woman trafficked to Cyprus and sexually exploited, not protected by the Cypriot police, and subsequently died in suspicious circumstances. Can I go to MS 354, please, and the court's assessment that begins at paragraph 272. And I commend the analysis from 272 to 282. 278 notes the increasing global significance of trafficking in human beings and refers to the Palermo Protocol and the Anti-Trafficking Convention, which demonstrate the increasing recognition at the international level of the prevalence of trafficking and the need for measures to combat it. And going over the page, the conclusion of this section of the judgment, paragraph 282, is that trafficking itself, and notwithstanding express reference in Article 4 of the Convention, trafficking itself within the meaning of Article 3A of the Palermo Protocol and Article 4A of the ATC falls within the scope of Article 4 of the Convention. So it's the Anti-Trafficking Convention as the culmination of international concern on this issue leads directly to the conclusion of the court that trafficking falls within Article 4. At 285, the court refers to its previous conclusion in the Siliadin case that contracting states had an obligation to penalise and prosecute acts related to slavery, servitude, and forced labour. And second sentence for 285, in order to comply with this obligation, member states are required to put in place a legislative and administrative framework to prohibit and punish trafficking. So that's what had previously been decided. The court observes that the Palermo Protocol and the Anti-Trafficking Convention refer to the need for a comprehensive approach to combat trafficking, which include measures to prevent trafficking and to protect victims, in addition to measures to punish traffickers. It's clear from those two instruments that almost all the member states of the Council of Europe have formed the view that only a combination of measures addressing all aspects can be effective in the fight against trafficking. Accordingly, the duty to penalise and prosecute trafficking is only one aspect of member states' general undertaking to combat trafficking. The extent of the positive obligations arising under Article 4 must be considered within this broader context. So the Palermo Protocol and the Anti-Trafficking Convention are relied upon directly to expand the reach of Article 4 from the previous Siliadin position towards a comprehensive approach, not merely prohibition and punishment, but also the further a combination of measures, including to prevent trafficking and to protect victims.
Refers to a combination of measures addressing all three aspects. So presumably that's measures to prevent trafficking, to protect victims, and to punish traffickers.
Yes.
Is that right?
Yes, indeed. The Anti-Trafficking Convention and Palermo Protocol, comprehensive approach, combination of measures. Therefore, Article 4 itself is explained as including all three heads of positive obligation rather than the one which had previously been identified in Siliadin. And Mr. Hussain also would like me to refer to paragraph 284. Now, paragraph 287, 286.
Well, 286 implies a duty of investigation, doesn't it? Or identification. Because you can't do all of those things unless you've identified people.
Yes, indeed. So I don't mean to skip over that. That is important. Operational measures must be taken to protect victims, including measures to identify who the victims are or may be. But then, in deciding how great is the obligation to take operational measures, paragraph 287, the court notes, well, of course, operational choices must be made. The obligation to take operational measures can't be interpreted in a way which imposes an impossible or disproportionate burden on the authorities. But then in deciding what is a proportionate burden, one has to look, the court goes on to say, at the Palermo Protocol, in that case signed by both Cyprus and Russia. So the international obligations there are under the Palermo Protocol, in other cases under the Anti-Trafficking Convention as well, they assist in identifying what is and is not proportionate by way of operational measures under Article 4. And 288 is the further explanation of the procedural obligation to investigate situations of potential trafficking, and 289 on the question of jurisdiction as between different countries which may be implicated in the same act of trafficking. The Strasbourg Court resolves the jurisdictional question with reference to the Anti-Trafficking Convention. So about halfway down 289, it says the Anti-Trafficking Convention explicitly requires each member state to establish jurisdiction over any trafficking offence committed in its territory. And it goes on to refer to obligations to cooperate effectively in cross-border cases as well. So again, the Anti-Trafficking Convention is dictating is highly influential in setting the content of Article 4. 296, in applying these principles to the facts of the case, the court refers to the obligations of the Cypriot authorities in the Palermo Protocol and the Anti-Trafficking Convention to ensure adequate training to those working in the relevant fields to enable them to identify potential trafficking victims, as an important part then of its conclusion, 296 and 297, that the police in Cyprus did not take sufficient operational measures in this case. They simply hadn't been trained to identify victims. So specific obligation in the Anti-Trafficking Convention translated into positive obligation under Article 4 becomes breach of Article 4. And one sees the same type of reasoning in paragraph 307, where Russia is held to be in breach of its investigative duty, with reference again to the international instruments which emphasise cross-border cooperation and emphasise that trafficking includes recruitment, and therefore the state in which recruitment takes place has an obligation to investigate as well. That's 307 and 308. So that's Rantsev. We say extensive reliance upon the Anti-Trafficking Convention to determine the contents of Article 4 ECHR. We say that is more than borne out, and indeed is seen to a greater extent in Chowdhury at tab 9, MS 180. The facts of this case.
Could you give me the number again, please?
MS 180.
Thank you.
I just have a date. What was the date of Rantsev?
January the 7th, 2010.
Was Rantsev a Grand Chamber?
Yes.
I thought so.
Oh, hang on. Sorry, no.
Wasn't.
Sorry, it's not.
Okay.
It's a large chamber, but not a grand chamber. 1, 2, 3, 4, 5, 6, 8. 7 judges.
That's the normal. What was it in those days?
Chowdhury then is first section, not grand chamber. The facts begin at 182, MS 182, paragraph 5, and just in brief summary, concerned trafficked farm workers in Greece. Around 150 of them had been involved in an incident, see paragraph 8, during a strike for their unpaid wages. The incident resulted in a guard opening fire on them, injuring 30 or so of the workers. The injured victims were accepted by the local prosecutor to be victims of trafficking, paragraph 11, but the others who were not injured and came to the police a little later were found not, or weren't accepted to be victims of trafficking. And when the traffickers were prosecuted, they were acquitted of trafficking and ordered to pay a pitiful amount of compensation, 43 euros each, to the individuals who had been shot. Paragraphs 87 to 89 of the judgment of the first section, MS 208 onwards, set out and repeat the RANSEV obligations. When applying those obligations, however, the court does rely again very heavily, we say, on the Anti-Trafficking Convention. Between paragraphs 93 and 100 from MS 210 onwards, the court relies on the definition of trafficking in Article 4A of the ATC for its conclusion in paragraph 100 that the applicants had been subject to trafficking. In paragraph 103, MS 213, the court reiterates the general obligation to take operational measures to protect actual or potential victims of human trafficking. And then 104 is we say, an important paragraph. More specifically, the Member States' positive obligations under Article 4 must be construed in the light of the Council of Europe's Anti-Trafficking Convention and be seen as requiring, in addition to prevention, victim protection and investigation, together with characterisation as a criminal offence and effective prosecution of any act aimed at maintaining a person in such a situation. The court is guided by that convention and the manner in which it has been interpreted by GRETA, that's the Committee of Experts, which issues reports on compliance with the Anti-Trafficking Convention. So this is an explicit finding that the extent of positive obligations under Article 4 is to be construed in the light of the Anti-Trafficking Convention. And that, we say, is directly contrary to the position of the Secretary of State on this appeal, contrary to the ruling of the Court of Appeal in Huang and Min, which I should say came before Chowdhury, contrary to the ruling of the Court of Appeal in our case, which came after Chowdhury.
How would that work in a case concerning Russia, which is not a party to the ATC?
Well, one saw from RANSEV itself that the court, that notwithstanding that fact, the court was able to rely on the ATC as reflecting the Palermo Protocol, as reflecting the position generally in international law. So for example, on the issue of jurisdiction, the court looks at the ATC effectively for what was the right answer to jurisdiction, notwithstanding that Russia isn't a party. So whilst one sees much greater reference to the Palermo Protocol in RANSEV than one does in subsequent cases because of that point, it doesn't make the Russia's non-signature doesn't make the ATC irrelevant.
Your submission must be surely that ATC informs the content of the Article 4 duty, and that content cannot vary according to the respondent to the application.
Yes, well, indeed, and I do say that. It gets a little bit more complicated where, in respect of the Strasbourg Court's approach of saying, well, we can judge what's proportionate in a particular case by what obligations the state has accepted at the international level to be proportionate. If it turns out in that particular case that the state hasn't actually accepted. So it may get a little more complicated there, but in general terms, I do agree. We're looking at Article 4 interpreted in the light of other relevant international instruments.
104 goes the concept of something being construed in the light of something else. It goes so far, doesn't it, as saying, well, you can use the convention for identifying terms of positive obligations, but it doesn't go so far at this stage.
No, well, it's not our position that you incorporate the whole of the ATC lock, stock and barrel. And I rely on this paragraph as really a complete answer to the rather extreme position of the Secretary of State that the ATC is only relevant for definitional purposes. It's plainly this tells us it's relevant for more than that. But I also rely when you ask, well, what does it mean for Article 4 to be construed in the light of the ATC? I point to other passages we've seen from Rant 7, I'll show you in this case, where there is a direct reliance on the ATC to establish the breadth of positive obligations in a particular case. What's proportionate? Let's look at the ATC. Obligation to provide trained staff and officers to deal with potential victims, that's in the ATC, that gets incorporated into Article 4. When one actually looks at how this approach is applied in practice, it goes considerably beyond simply taking the ATC into account.
So just to try and pin it down, you would not say that any breach of the Convention is a breach of Article 4?
No, I don't say any breach of the Anti-Trafficking Convention is a breach of Article 4. I do have submissions which I'll come on to the effect that in most cases a breach of certain provisions of the Anti-Trafficking Convention will amount to a breach of Article 4, but I don't seek to transpose the whole of the ATC.
Can you offer any kind of yardstick or analytical tool that enables the go through the ATC of it do or don't get, if you like, transferred into positive obligations under Article 4?
Well, I hope by the end of my submissions that I will have provided some help on that. So if you don't mind, I won't do that now.
Take your time, but that's what I'm looking for.
Yes, no, I understand that. But let me just finish with Chowdhury. 110 onwards, when looking at the operational measures which were taken by Greece in this case, paragraph 110 starts with a reference to the ATC. It calls on member states to adopt a range of measures to prevent trafficking and protect the rights of victims, and then sets out a series of those measures and this paragraph reflects the detail of the ATC in these particular respects. So that is effectively the yardstick against which the conduct of the Greek authorities is judged in paragraphs 111 onwards. And one gets to the conclusion, in the light of the foregoing, at 115, the court finds the operational measures taken were not sufficient to prevent human trafficking or to protect the applicants from the treatment to which they were subjected. So it is, in our submission, highly significant that the court is setting up some quite detailed provisions of the ATC as the yardstick against which the Greek authorities' conduct is to be judged. 121, there's a further instance of this where the court criticises the finding of the Greek prosecutor that the non-injured workers couldn't be victims of trafficking because they had delayed in coming to the police. And the court says in 121 that is inconsistent with the period, the recovery and reflection period required by Article 13 of the ATC, which insists that individuals be given that minimum breathing space after coming to the attention of the authorities. and then 126 in relation to the compensation which was ordered to be paid by the Greek authorities. There is again a reference to a specific provision of the ATC, Article 15, right to receive compensation from the perpetrators of the offence. That is the yardstick against which the Greek authorities' conduct is found to be deficient under Article 4. So there are both in Chowdhury and in Rancev, we say, there's a series of specific applications of the provisions of the ATC as the basis for finding of breach of Article 4. Jay and Austria, in the light of the time, I'm not going to go through this in detail now. What we say that it shows is a similar reliance by the Strasbourg court on the Anti-Trafficking Convention, but this time in order to find that the contracting state had complied with its obligations, a submission which the Austrian authorities made in paragraph 94, MS 246, accepted at paragraphs 110 to 111 and 114. So, to be clear, and as I've have already made clear to the court, we do not say that every breach of the Anti-Trafficking Convention equates to a breach of the Article 4 positive obligations, and still less do we say that every breach of the Anti-Trafficking Convention will invalidate a removal decision. Of course, whether or not a breach of Article 4 positive obligations has occurred is sensitive to the facts of the individual case, and it will depend in an individual case whether it would be disproportionate to require the defendant to have taken further operational measures than were in fact taken to protect victims, to investigate and prosecute offences. But we do say that a breach of one of the core provisions, and that's Articles 10, 12, 13, 14 and 23, will usually give rise to a breach of Article 4 of the Convention, of the ECHR, both because of the enhanced legal status of the ATC at domestic level and because the obligations that the UK has accepted at the international level are the best guide to what it is proportionate to expect pursuant to Article 4 in any individual case. Now, I've said that I disagree, or we disagree with the finding to the contrary of the Court of Appeal in the Huang and Min case. Can I just show you that briefly at Bundle 1, Tab 8, MS 164. This was a challenge to the finding of a Deputy High Court judge that a failure to apply the Secretary of State's competent authority guidance equated to a breach of Article 4 in that case. And one sees the finding in question at paragraph 22 at MS 173. And the conclusion of the Court of Appeal on the challenge to that finding is in paragraph 41, MS 178. Where you see Lord Justice Burnett says the judge recorded as uncontroversial the proposition that if the procedures adopted by the Secretary of State did not match the demands of the Anti-Trafficking Convention, that might be persuasive evidence that there had been a breach of the investigative obligation under Article 4. In my view, that proposition is not supported by the decision of the Strasbourg Court in Rantsev. It draws on the Anti-Trafficking Convention for the purpose of establishing the scope of conduct prohibited by Article 4, but the obligations of the former are not read over directly into the procedural obligation under the latter. The judge was led into understandable error for want of argument on the point. And one finds a further explanation for the Court of Appeal's view in paragraph 34, MS 177. Again, it said the Anti-Trafficking Convention is only relevant to define conduct which falls within the scope of Article 4. However, the step-by-step procedures envisaged by the ATC were not read over in Rantsev as providing a surrogate for the procedural obligation under Article 4 ECHR. And we say that the position is somewhere in the middle of those two propositions. We're not suggesting that the step-by-step procedure is directly incorporated into Article 4, but the Anti-Trafficking Convention has considerably greater significance than simply to define what trafficking is. The Court of Appeal in this case also makes findings as to what it regards as the very limited role of the competent authority in complying with Article 4 obligations. And that's in particular at paragraph 31 at MS 176. And the
Sorry, what page?
I'm sorry, MS 176. And the Court of Appeal says, for example, in the second sentence, the functions performed by the competent authority have no bearing at all upon the second aspect of the procedural obligation identified by the Strasbourg Court, urgent investigations to relieve those subject to coercion, because it is concerned with the position of someone who necessarily is no longer subject to coercion, whatever may have been the earlier position. And it goes on. The authority isn't an investigative body, and so forth. Now, that betrays, we say, what may be, in certain cases, an important misunderstanding of the position of victims of trafficking, simply because they've been referred by a social services department, for example, as in the present case, doesn't mean that the victim is no longer subject to coercion or other forms of psychological control. That's the reason why there's the reflection and recovery period under the Anti-Trafficking Convention, which kicks in after referral and after the reasonable grounds determination, because it's to give the breathing space to escape from the influence of traffickers and to recover from the experience, to decide whether to cooperate with the authorities. And victims will very often, we say, need practical support, for which the competent authority is the gateway, in order to avoid falling back into the hands of traffickers, to break economic dependence, they'll need somewhere safe to stay, and so forth. So the failings of the competent authority in its reasonable grounds determination, or indeed if it gets past reasonable grounds in its conclusive grounds determination, we say can lead directly to a breach of Article 4 of the ECHR, even though the Convention is there to comply with the anti-trafficking, the competent authority is there to comply with the anti-trafficking Convention. A failure to identify a potential victim will result in a failure to provide the necessary package of support and may expose victims to a risk of trafficking in breach of the protection duty. Also, in practice, and as we see in the present case, if the competent authority decides that an individual referred is not a victim of trafficking, then the police are most unlikely to investigate whether any crime has occurred. And that may in turn then lead to a breach of the investigative duty under Article 4. Now, against that background, I'll then move rather more quickly through part 2 of my submissions, which concerns the application of the Anti-Trafficking Convention and Article 4 in MS's case. And I will consider the position before the removal decision and then the effect of the removal decision itself. Now, on the facts of this case, we say there was a breach of several provisions of the Anti-Trafficking Convention before we get to the removal decision. First of all, a breach of Article 10 of the Anti-Trafficking Conventions in relation to the identification of victims, reasonable grounds determinations, for the reasons given by the upper tribunal, which I will come back to. There was a wholly inadequate approach taken to deciding whether there were reasonable grounds to suspect that MS was a victim of trafficking. So there was a breach of Article 10.2 through the failure to acknowledge MS as a potential victim of trafficking, and the consequent failure then to offer him the assistance required by Article 12 for individuals who do pass the reasonable grounds test. So a breach of Article 12, the assistance obligations as well. A breach of Article 13, he was not afforded the recovery and reflection period, which he should have been afforded had he properly been identified at the reasonable grounds stage.
I mean, do we know, as a matter of fact, what happened to him after his first referral to the competent authority?
Lord, I'll answer that question in a moment, if I may, Mr.
Because, I mean, as I understand it, recovery and reflection is meant to be a period where you are separated from your previous traffickers, during which you have a chance to be emancipated from their control.
Yes.
And I just don't know, after he was referred, what in fact he was doing or what happened to him, as a matter of fact.
So it's not simply to ensure a physical separation.
No, of course.
From the traffickers. It's to enable both recovery and various forms of assistance to that end, and reflection as to cooperation with the authorities. What in fact the first competent authority decision said was that he didn't need that period because he had physically been away from the influence of his of the original traffickers for some period of time. But we would say that took no account of his subsequent exploitation after the initial traffickers had finished with him, and nor does it take into account the need for him to receive Article 12 assistance to recover from the experience. So he didn't have the period he should have had the competent authority taken the decision at the reasonable ground stage that it should have taken. We say there was also a breach of Article 14(1)(b) of the Anti-Trafficking Convention because MS was not granted a residence permit in order to enable him to continue cooperating with the investigative and subsequent criminal proceedings. We understand that he was at all times willing to cooperate, but the evidence shows, as I'll come on to it in a moment, that no investigation took place. But he should have been offered the opportunity to remain in the country in order to cooperate with an effective investigation. And then Article 23(1), there had been, by the time of the removal decision, a failure to conduct any effective investigation into the trafficking offences committed against MS.
What type of residence permit is usually given in those circumstances?
It's discretionary leave to remain of up to 30 months. The presumption is 30 months, and the decision maker can depart from that in the circumstances of a particular case. I did notice that you don't have the guidance on discretionary leave to remain, which applies to this situation. We can provide that in due course. So that's the position. In terms of Article 4 of the ECHR then, before the removal decision was taken, there had been a failure to take operational measures to protect MS at the point at which he came to the attention of the authorities when he was initially referred. And that includes, we would say, as part of the positive obligation, the recovery and reflection period and the assistance to which he was entitled during that period. And there had also been, by the time of the removal decision, a failure to conduct an effective investigation as required by Article 4. Now, turning then to removal, removal decisions generally, we say there are a number of different ways in which a breach of the Anti-Trafficking Convention may affect whether a removal is a breach of Article 4 of the Convention. The Secretary of State accepts that this will be the case, that there will be a breach of Article 4 of the Convention if there is removal in circumstances of a risk of re-trafficking on return to the country of origin, and that's the Suring type duty imposed by Article 4, and of course we agree with that. That's the Secretary of State's case, paragraph 56, MS 2289. But there are other situations in which removal will also breach both the ATC and potentially also Article 4 of the ECHR. For example, removal during the recovery and reflection period required by the Anti-Trafficking Convention, we say, will very likely lead to a breach of Article 4. The individual will not have been afforded the minimum period which the UK has accepted is necessary to overcome the trauma of trafficking and to escape the influence of the traffickers. And that is likely to create a real risk that the individual will fall back into the hands of traffickers on return. Removal during the recovery and reflection period, or before the recovery and reflection period has been completed, is also likely to result in a breach of the investigative duty under Article 4, because the individual will not have been afforded the period which is recognised to be appropriate for deciding whether to cooperate with a criminal investigation and subsequent prosecution. And of course, in UK terms, it's unlikely that an effective investigation will have been conducted within the 45-day recovery and reflection period for which the guidance provides here.
I think we know what the average length of time it takes
Yes.
at the moment,
Yes, you do.
and how it has been increasing dramatically over the last few years.
And that may have the happy outcome in some cases that the effective investigation can be completed before the end of the period, but overall it is an unhappy situation. Removal during the longer period in which the needs of the victim of trafficking call for other forms of Article 12 support, again, may breach the protective obligation, the obligation not to protect victims of trafficking. And of course, with reference to removal, the decision whether to grant a residence permit under Article 14 of the Anti-Trafficking Convention is an important safeguard against breach of Article 4. Both to avoid the risk of the individual falling back into the hands of traffickers, and to permit the individual the time that's necessary to cooperate with an effective criminal investigation. Now, what was the breach of Article 4 in this case? In this case, the Upper Tribunal's conclusion, paragraph 64, MS 2421, under Article 4, was that removal of MS was a straightforward breach of the investigative obligation. There had been no effective investigation to date. Effective investigation and prosecution could not take place if MS was removed to Pakistan. We say that conclusion is unimpeachable. The position on the evidence was that there had been no police investigation. MS was arrested in September 2012, but referred immediately to Tower Hamlets Social Services. No evidence of any investigation at that stage. The competent authority then decided that there were no reasonable grounds to suspect that MS was a victim of trafficking, and therefore did not refer his case to the police. And nor is there any suggestion that anybody else referred his case to the police. The Secretary of State rightly does not suggest that an effective investigation could take place after MS had been removed to Pakistan. We have two authorities in the bundle by way of illustration of the difficulties of individuals giving effect to their procedural rights, participating in legal proceedings after removal. One is the Chiari case on out-of-country appeals, Bundle 2, tab 24, MS 737. And the other is the case of Kwa, second supplementary authorities bundle, tab 68, MS 2956.
I don't think that in the supplementary bundle, although it's marked with the follow-on pages, in fact, electronically we need the page reference to that bundle.
I don't currently have, I think, an electronic second supplementary bundle, unless it's been incorporated into some other bundle.
No, it hasn't, but there is a separate bundle.
Yes.
There's a
I
separate
don't know
bundle
why I haven't, and I'm not blaming you for it.
So what's the name of the case that you were?
It's Kwa, Quaquah. It's tab 68.
It's listed as. I see what you mean. Qua, yes.
And again, it just
Yes, I've got that. That's 182 of the supplementary bundle.
it's 182 of the supplementary. Oh, I see you. Yes, I'm afraid I don't have the
It's on the G drive.
same page.
So, supplementary.
But in any event, it's another example of the courts saying, well, it's extremely difficult for somebody to participate there in civil litigation after they've been removed to a faraway place. So, although the Secretary of State does not suggest that an effective investigation could have taken place after MS had been removed to Pakistan, what he does say, she does say, I'm sorry, and this is an important point, the Secretary of State's case, paragraph 59, MS 2290.
I'm sorry, the paragraph again.
59.
Thank you.
2290. So what Sir James argues in that paragraph is it might be possible to argue that removal breaches the investigative duty on exceptional facts, but only where removal would prevent the state discharging its investigative function, and that constituted a fundamental breach, not just any breach, a fundamental breach of the appellant's Article 4 rights. And we say there is no warrant for these qualifications upon the acceptance of an obvious point. Exceptional facts, no, it's quite straightforward. Has an effective investigation taken place or not? And we don't, with respect, understand the reference to a fundamental breach of the appellant's Article 4 rights. Any breach of Article 4 is fundamental. It's also argued in paragraph 61 of the Secretary of State's case that 61.2 circumstances may have moved on such that an investigation or a prosecution is impossible or inappropriate. Well, that may be the case, but that can't be determined without cooperation from the individual before he or she is removed from the country. Of course, an investigation which, despite all best efforts, runs into the sand, may be an effective investigation, but you can't say from the start and without that having taken place that there's no breach of Article 4.
What happens if subsequent events disclose that no effective investigation could have been taken? Is the Secretary of State in breach of Article 4 if she or he has not commissioned an investigation, notwithstanding that subsequent events prove that it couldn't be effective?
Yes, is the answer to that. There should be an investigation before removal. If there is no investigation before removal, that is a breach of Article 4. If it is demonstrated that the absence of any investigation made no difference because it would have been because it wouldn't have led anywhere, well, that may affect the remedy, which is to be afforded to the individual, but it doesn't affect the need for the investigation in the first place.
No, but the question we're looking at is whether the breach renders the removal unlawful.
So what is
We're not at the remedy stage, I think, are we, at this point? We're trying to see whether there is a relevant nexus between the breach, in this case of the Convention, and possibly Article 4, and whether that renders a removal, while that breach is, as it were, has happened and hasn't been remedied, itself a breach.
Yes. To which my answer is yes, it's still a breach. You can't remove and then look into, after you've removed, whether that's made any difference. But the question of whether removal made any difference to the individual, because, for example, an investigation wouldn't have led anywhere even had it been conducted, that can only go, is my submission, that can only go to remedy. You can't remove first and then ask yourself, well, what's been lost as a result?
Yes, but by the time you get to the tribunal, which is looking at it on the basis of the facts as at the time of the tribunal, it might by then be apparent that the investigation would have led nowhere. So you'd have a breach of Article 4 obligations to investigate, but you'd still be looking at the grounds of appeal as set out in the Act, wouldn't you? And they talk about the decision is unlawful under Section 6 of the Human Rights Act. The decision is are we then going back to the time when the decision's taken? I mean, it becomes rather confusing as to what time you're looking at things. So is it the removal now, or is it the decision then?
It's whether removal now would breach the convention rights of the individual. As I said, the standard approach is the tribunal looks at the facts as they stand when the case comes before it. And I'm sorry, no, you put the question perhaps in a way I didn't quite understand before, but we would accept that if one is before the tribunal challenging a decision on removal and it can be established that there was nothing that could have been done anyway on an investigation, then removal would not breach the Article 4 investigative duty.
So we're looking then at the actual removal and whether it would breach Section 6 or whether removal is otherwise not in accordance with the law, not at the process of the decision maker when deciding to make the removal order.
Yes, I mean, there may, of course, be a relationship between the two, so far as the convention ground is.
Well, it starts to get very complicated when you start to talk about the decision is otherwise not in accordance with the law, and then we start looking at how they made it and whether they omitted to take into account the relevant factors and that sort of thing. And then you're looking at the decision-making process rather than the removal itself.
Yes. So, Mehdi, I need to distinguish between the convention ground
Yeah,
and the in accordance with the law,
yeah,
or not in accordance with the law
Yeah.
ground. I've been dealing so far with the convention
Yeah.
ground, and I hope I've given
and that's looking forwards, removal now. Yeah,
that, but undoubtedly not in accordance with the law. Can it be shown that the removal decision is not in accordance with the law? That does depend on looking at what the process of decision making which led to the removal decision.
I think you conceded that if it's apparent by the time the tribunal comes to look at it that there could never have been an effective investigation, then a removal at that stage, at that later stage, would not be contrary to Article 4. What about a situation where maybe an investigation could have been effectively carried out at the earlier stage, but by the time it gets to the tribunal, it no longer can? Does the fact that the opportunity of a historical investigation has been lost mean that removal at the later date is contrary to Article 4? Or does the fact that by then it's hopeless mean that it would no longer be contrary to Article 4 for that reason? That might be nearer the facts of this case.
Well, my Lord,
But I'm just looking at it in the abstract at the moment.
yes, I don't think I would accept that it's near the facts of this case. I think I would accept that if an effective investigation, if the tribunal concludes that an investigation is impossible or would lead nowhere when the case comes before it, that may well imply that there has been a breach of Article 4 in the past, for which there may be a separate remedy, but it wouldn't make the removal in breach of Article 4, because the basis for the argument and the basis for the finding of the tribunal, of the upper tribunal in our case, is that removal prevents an effective investigation. So on my Lord's facts, that wouldn't be the case. The Atamuan case that I referred to briefly for Sir James's concession, Bundle 2, tab 30, I don't have time to go back to it.
You've only got about 5 minutes, I'm afraid, Mr. Coppell.
I know. But it is a useful example, similar to the present case, of removal in circumstances where the individual had wrongfully failed to be identified as a potential victim of trafficking, and an investigation had not taken place. And what in fact the divisional court decided in that case was that the Secretary of State had to recover the individual from Nigeria to bring her back to the UK and to go through the steps which should have been taken pursuant to the Anti-Trafficking Convention and the guidance. But a useful example, analogous in some respects to the present case, that shows the upper tribunal was by no means out of line, and it's a case to which the upper tribunal refers. Can I then deal, what will have to be quickly, with not in accordance with the law? This issue may be, depending on the numbers of outstanding cases, of esoteric interest. We say it doesn't matter in the present case, as MS succeeds on human rights grounds. In the present case, there is common ground that the Court of Appeal adopted the wrong approach under not in accordance with the law, it is not necessary for the tribunal to conclude that a competent authority trafficking decision is perverse before it can examine for itself whether the appellant is a victim of trafficking, and then assess for itself the relevance of that for the decision under appeal. It's also, I believe, common ground that the exercise engaged in by the upper tribunal in this case of considering whether there was any public law error in the trafficking decision and then the removal decision was a legitimate exercise. We disagree as to whether the upper tribunal was correct to find that there were public law errors. I'll come back to that in a moment. There is an interesting question, maybe an academic question, but there is an interesting question which arises from the Court of Appeal authorities in Abdi and AS Afghanistan, whether it is sufficient for a removal decision to be not in accordance with the law if it has been taken on the basis that the appellant is not a victim of trafficking and so is not subject to the policy on trafficking victims, when the tribunal exercising a fresh fact-finding jurisdiction considers that he was. If that is sufficient for a not in accordance with the law finding, that would suggest that the tribunal should always engage in a fresh determination of the trafficking issue, this head as well, regardless of whether there were any public law, any other public law defects in the competent authority decision. Now, Abdi suggests that that is the right analysis. Failure to apply a policy which the tribunal considers on the facts should have been applied is an error of law, sufficient for a not in accordance with the law finding. That's what Abdi says. AS Afghanistan, we say, can be read either way. It relies upon Abdi and concludes in paragraph 17 of the Court of Appeal's judgment in AS Afghanistan that the first-tier tribunal should, if asked, decide whether in fact the trafficking policy was complied with, as this may be relevant to the removal decision. But the analysis in AS Afghanistan is somewhat complicated by the fact that the Court of Appeal in that case regarded the trafficking decision as being irrational, and it's at times not clear whether references to irrationality are simply a reflection of the facts of the case or a restriction on the principle which the Court of Appeal is intending to express. We would submit, if the court wishes to get into this issue, that the Abdi approach is the correct one, but the court may take the view that it's simply not necessary to go into it. Public law errors in this case, in MS, we say the upper tribunal rightly identified errors in paragraph 55 of its decision. Failure to properly analyse the factors of the appellant's pay, accommodation and mobility. I'm sorry, it's MS 2419. Failure to properly analyse the factors of the appellant's pay, accommodation and mobility. Failure to identify the elements of fear and coercion. Paragraph 56. Various respects. And the only question remaining is whether those errors were sufficiently material to the removal decision. And I'll give you two short reasons why the public law errors were sufficiently material to the removal decision in this case. First of all, the Secretary of State had failed to consider his policy of granting discretionary leave to remain for 30 months to victims of trafficking, potential victims of trafficking who wish to cooperate with the authorities. having not identified MS as a victim incorrectly, no consideration was given to that important factor which bore upon his removal. And secondly, the upper tribunal rightly found at paragraph 59 that had MS been properly regarded as a victim of trafficking, he would have been granted a residence permit, and that would have given him the chance of securing leave on a longer term basis. That is a historic injustice, as the upper tribunal said, and historic injustice will be a material consideration for the decision maker when deciding whether or not to remove. It may also affect the balance under Article 8. I've gone slightly over my time.
You have, just a bit.
Sorry. Unless I can assist further, those are my submissions.
Thank you very much, Mr. Cockle. Thank you. Mr. Butler? Now, what are you two doing about the short amount of time that you have between you?
My ladies, my lords, I'm going to deal very briefly with the jurisdictional issue about which there's a concession. And I'm going to deal, if I may, with just 2 points. First of all, about the scope of the concession. And secondly, a recent decision of the upper tribunal in a case called DC. Yes.
Too far away.
Do apologise. So I'm going to deal with the scope of the concession and also the decision in DC. Mr. Hussain will deal with Article 4 of the Convention and the Anti-Trafficking Convention. In practical terms, obviously, the jurisdiction issue is quite important, as my Lady the President indicated earlier. And that's not least because if appellants in the first tier tribunal are bound by the competent authority's conclusive grounds decision, save in cases perhaps of irrationality, that of course will have a profound chilling effect on a victim's willingness to even enter the national referral mechanism in the first place. Given the sometimes poor quality of the Secretary of State's decision-making, the rational advice which an immigration lawyer would give in those circumstances is not to enter the national referral mechanism at all. In other words, give up participation in the national scheme which is intended to implement the Anti-Trafficking Convention in order to preserve the first-tier tribunal's full fact-finding jurisdiction in your asylum or human rights appeal, should that prove necessary. Otherwise, you'll be effectively at the mercy of the Secretary of State's decision-making. Now, I raise that because the Secretary of State's concession, which is rightly made in the Air Centre's submission, does come with a slight gloss. And the way the concession has been worded has been set out in paragraph 65 of Sir James's written case. That's at MS 2291 in the core volume. The way it's put at MS 2291 paragraph 65 is that the tribunal is required to determine the relevant factual issues for itself on the basis of the evidence before it, albeit giving proper consideration and weight to any previous decisions of the defendant authority.
Sorry, paragraph again?
65.
65, thank you.
At the bottom of 2291. Now, the first part of that is, of course, fine. The reference to proper consideration and weight perhaps requires a little more care, because it's a reformulation of what the House of Lords said in Huang about the proper approach of the immigration appellate authorities. Of course, every few years, this court or its predecessor ends up hearing appeals where the issue is the proper scope and effectiveness of immigration appellate decisions. So the last example was Kieri and Bin Loss, where the effectiveness of appeals would have been fundamentally prevented if they had to take place with the appellant abroad. But if I could very briefly just go to Huang to indicate what I say is the correct formulation of the proper approach to be taken. Huang is in the first bundle of authorities at tab 11, MS page 76. tab 4 of the first bundle, MS 76.
Sorry, you're taking us to
Tab 4 of Authorities 1.
yes. Wang.
That should be the decision of the House of Lords in Wang. At MS page 76, two passages from the judgment of the whole committee, which was given by Lord Bingham. First of all, paragraph 11 sets out the task of what is now the first tier tribunal. I won't read it out because it's a well-known passage, but the duty of the authority is to decide for itself whether the decision is lawful. And then at paragraph 15 on page 78 in the MS numbering, Lord Bingham sets out the approach to findings of fact, and the approach of the Immigration Appellate Authority is to establish the relevant facts. And he notes that things may well have changed, and it's important that the facts are fully found and set out in the relevant decision. That, in my submission, is the correct approach. A competent authority's decision is going to be relevant to the extent it is persuasive and compelling for the quality of its factual analysis. No more than that, and no less than that. It's no different from the approach which the first tier tribunal might take to a decision of the Secretary of State, for example, refusing asylum, which will of course contain the Secretary of State's detailed views as to the facts. It may or may not be persuasively analysed on the facts, and it may or may not be helpful. It of course should be read and considered with care, but ultimately the fact-finding task is one for the tribunal. Indeed, that is the very purpose of the appeal, to see whether or not the decision is right on the factual material before the tribunal. And of course it's usually the case that the factual material will be better before the tribunal because it will have the benefit of examination and cross-examination of witnesses, expert evidence, and the benefits of an adversarial trial. So the Air Centre does say caution the gloss in the concession properly made by the Secretary of State. The second point, which I was going to make, is that whilst this appeal has been pending to this court, the upper tribunal has been doing its level best to explain the Court of Appeal's decision in MS Pakistan. There have been a number of decisions of the upper tribunal, and the most recent of those is the decision in DC, which does go some way to identifying the correct position on this jurisdictional issue. But before this court, or if this court are asked to adopt the formulation in DC, again, we do encourage a little caution, not least because the upper tribunal in that case were being entirely appropriately careful in the handling of a decision of the Court of Appeal that of course bound the upper tribunal. The decision in DC is in the Supplemental Authorities Bundle, Volume 5, at tab 63, and MS 2116.
No, it won't be.
No, it won't be.
Yeah.
It's some much lower page number.
You say it's tab 63?
Tab 63,
Ah, right. Well, that is in the original bundle.
fingers
So-
crossed,
Yes, it is in the original. 2113, did you say?
2116, my lady.
Yes, it is.
Wonderful.
I'm afraid, Mr. Jeffrey, my supplementary bundle starts at 64.
Yes.
Yes.
Bundle 5, my lord.
Thank you.
There are two supplementary bundles. One of them got the number 5, and the other one is a second supplementary bundle.
But do we need to bother with this if the upper tribunal is struggling to make sense of what the Court of Appeal said in this case? And we know that what the Court of Appeal said on this point is not correct. What we replace it with is another matter, but we know it's not correct. So do we?
The only reason I'm proposing to show you this is to identify what, in the Air Centre submission, you should say.
Right.
The key passage is paragraph 34 in the judgment, which is at MS 2123. The first thing which the upper tribunal says at paragraph 34 is that in an appeal against the refusal of a protection claim under section 82(1)(a) of the 2002 Act, The assessment of the risk of return, whether in terms of the Refugee Convention or Article 3, is for the tribunal to determine. Well, the correct position goes further than that. There are two other classes of case. An Article 4 claim, such as is before this court, or an Article 8 claim. So that's, in our submission, a significant omission. Then at paragraphs 35 to 37, the upper tribunal gives some guidance on findings of fact, and they entirely correctly note that the tribunal may well have better evidence and will often be applying a different standard of proof to the Secretary of State, acting as the competent authority. And so some examples are given of possible cases where the Secretary of State may be wrong, perhaps because new evidence has come to light. And the Secretary of State may have been wrong in either direction. There may have been new evidence which comes to light, which tends to suggest that someone was not a victim of trafficking, as well as that someone was a victim of trafficking. But it does go further than that, and the way in which it goes further is that the fact-finding exercise, which is carried out by the first-tier tribunal, may, even on the same facts, lead to a different conclusion, because the decision-making process is conducted de novo. Even on the same evidence as was before the Secretary of State, it's entirely legitimate for a first-tier tribunal to assess the facts itself and come to the conclusion which it thinks right, applying the standard of proof which it does in the cases which are before it. So the submission is essentially, first of all, that Huang is the touchstone. The tribunal determines the facts for itself, de novo, and the Secretary of State's decision is frankly no more than the reasoned view of a party which is before the court as to the facts which may be found by the tribunal. And questions of fact are ultimately for the independent court, the first-tier tribunal. Those are my submissions, if I may, on the scope of the concession which is made and how the court ought to approach the question of jurisdiction. With your permission, Mr. Hussain will deal with the convention and ATC issues.
Yes, thank you very much, Mr. Chair.
My ladies, my lords, ECPAT UK is very grateful to the court for granting it permission to intervene. My aim, as Mr. Jaffe indicated, is to supplement the Commission's submissions on Article 4. I'm going to seek to address, first of all, the relationship between Article 4 and the ATC, and I'll suggest a yardstick. Secondly, I'll focus on the investigative obligation and how that may be breached by removal, focusing on historical cases. And if there's time, I'll say something else about the protective and systems duty. So firstly, the relationship between Article 4 and the ATC. The answer to the questions that came from the court, particularly my Lord Lloyd Jones, relating to the fact that Russia isn't a party, is given by the Demir case. This is the Grand Chamber. It's the leading authority on the relationship between the European Convention on Human Rights and other relevant treaties. And you have that, I'm afraid, in the supplementary bundle at tab 64. I don't want you to take you to it, given time. My MS page number is 2778, but you may have something else.
Which paragraph is it?
The relevant paragraphs are 61 to 86.
This is Demir and Turkey.
Exactly, my lords. Grand Chamber, and it's page 4, I think, of your bundle. The new
54. No, sorry, that's wrong. It's page 4. You're quite right.
The relevant paragraphs, I can't give you the page number, the relevant paragraphs are 61 to 86. So this was a case about whether Articles 5 to 6 of the European Social Charter, to which Turkey wasn't a party, could inform the right to free assembly and association in Article 11. And the court basically identified broadly 3 bases upon which it could, even though Turkey wasn't a party. First, Vienna Convention, Article 31(3)(c). Perhaps my lord was thinking about the fact that you've got to have an instrument that is applicable between the parties. And how can you apply Vienna Convention if Russia isn't a party. But the answer is that's not the only basis. The other bases are evolutive, living instrument, and giving practical and effective protection to the European Convention, a treaty with a special character. And therefore, it's not necessary for a state to be a party. And you get that from the following paragraphs. At 61, Turkey says the court can't create new obligations, redolent of Sir James's submission, it appears. 65, you have VCLT. 66, you have practical and effective. 68, you have evolutive. And at 70, they actually cite Siliadin, an Article 4 case, the first Article 4 case before the court. So that's the answer. It's not just VCLT. I know there's an ILC fragmentation report on this area, but that's not the position. It's not simply the VCLT.
The third basis was, once again, please.
The practical and effective protection being given to the European Convention, a treaty with a special character.
Thank you.
Because it promotes human rights. But that's Grand Chamber authority, my lords. It reviews a number of cases. There are other cases in the Grand Chamber which talk about the need to construe the Convention, quote unquote, in harmony with other rules of international law which it forms part.
Al-Adzani, for example.
Al-Adzani, exactly. Al-Adzani, there's also Neulinger. But Al-Adzani is one of the famous cases. And Demir is explicitly applied by Rantsev at paragraph 273. And you have that at MS 354. And contrary to the Secretary of State's submission that the ATC simply forms part of the regulatory context for assessing state action, as if it only has descriptive force, it's clear that it has normative force. It can be used to read in ahead of protection to Article 4. That happened in the J case. The head is support. It's unsurprising that the court looks to it for what the incidents of protection require, because the general duties of systems investigation protection are given detail in the ATC. Chowdhury says more specifically at 104. The Court of Appeal in TDT at MS 124, this is Lord Justice Underhill, said that the two treaties, quote unquote, closely interrelate. He said at paragraph 12, MS 126, that the ATC is a source in practice of certain obligations under the ECHR. Perhaps that should say a source as a matter of legal interpretation. As far as Article 40 sub 4 is concerned, Malone Friend was good enough to read out to you paragraph 40, subparagraph 1, which makes it clear that the ATC is a ceiling and not a floor. And a similar provision occurs in every single major human rights treaty over the last 70 years. I can give you a list. But you have a treaty, it's always intended to be a ceiling, a floor. Sorry, I think I got to go.
Yes, a floor, not a ceiling.
Not a ceiling, sorry. But you've got that in every single treaty. ECHR Article 43, Refugee Convention Article 5. The list goes on. Every single one. Yardstick. My Lord Briggs asked for a yardstick. We would say two things. First of all, precedent. You look at the Strasbourg case law to take account of it. There's no good reason not to follow it. There is a clear and consistent jurisprudence applying the ATC to inform and flesh out the obligations under Article 4. But as a matter of principle, we would say, is the relevant ATC provision connected by reference to its concern or aim with one or more of the Article 4 obligations? The Article 4 obligations being systems, investigation and protection, and also SURE on return. And the question is, if you've got that, then is there substantial compliance with the ATC? We don't say there's a one-to-one equivalence. Of course we don't. So you've got to have substantial compliance, and if you haven't got that, you've got to have very good reason for not having substantial compliance. That's all I wanted to say about the relationship. May I please move to the investigative duty? This is always very important, but particularly so on an appeal where there's no stirring risk. The duty begins with a credible suspicion of prohibited treatment and ends with the conclusion, following a lawful and proper investigation, that the individual isn't in fact a victim, or if they are, with the end of the criminal process. It is a duty to investigate effectively in a way that's capable of leading to a successful prosecution. It's an obligation of means, not a result. And very importantly, a provision which appears in all of the cases, but which is notoriously absent, conspicuously absent, in my learned friend Mr. James's case, is that the victim or next of kin must be involved in the procedure to the extent necessary to safeguard their legitimate interests. So the victim in a trafficking case isn't simply an essential source of evidence, but is also is a participant in his or her own right. She's not simply an instrument, but a stakeholder. And at paragraph 37.5, MS 2281, Sir James's case omits that. This is demonstrated, for example, by Rantsev at paragraph 239, where the applicant's father wasn't informed of the inquest verdict until 15 months after the hearing, and that amounted to a breach. It went way towards establishing Cyprus's breach. That's MS 345. There's no question about him giving evidence. He wasn't there. As the anti-trafficking monitoring group, to which my client is party, says in their report, and this is MS 2633, Appendix Part 2, 2633, the conviction of the perpetrators is fundamental to redress and a significant aspect of rehabilitation. It is obvious, we say, and far from exceptional, that the presence of the victim in the territory will normally be necessary, if not always, for the duty to investigate and prosecute to be discharged in any effective and lawful way. A removal decision will normally, perhaps always, violate Article 4, where it risks frustrating the effectiveness of the application or of the investigation, because returning the appellant to circumstances may give rise to a whole range of practical difficulties. Video links aren't straightforward, see the Chiari case, as well as emotional difficulties, given the vulnerability and the importance of building trust with these poor victims. As Ms. Duran, on behalf of my client, says at MS 2608, paragraph 28, disclosure is a process rather than a single event. Also, if the appellant can't participate, that important right to participation, that will frustrate the investigative duty. Now, I haven't mentioned the ATC at all until now on this part of the case. This flows squarely from Article 4. But the ATC reinforces this, it fleshes it out. If you look at, I'll just give you references, please, if I may. Article 12.1e, MS 415, this recognises the need for assistance to enable the victim's rights and interests to be presented and considered at appropriate stages of the criminal proceedings. And the reflection period you've already looked at under Article 13. And the explanatory report to Article 13 says at page 456 of MS 456, this period is likely to make the victim a better witness. Statements from victims wishing to give evidence to the authorities may well be unreliable if they're still in a state of shock from their ordeal. And these observations come in the context of support. Support is very important to the discharge of the investigative duty. You can't expect a proper investigation and prosecution if you just leave the victim on the street. And that also, the support in the context of investigation also finds expression in the SM case, volume 4, tab 45, paragraph 69 to 72, MS 1391. The court considered whether support and assistance provided for the purposes of investigative duty was sufficient. We agree with Mr. Coppell, no need for flagrancy or fundamental breach, if that's a way of getting flagrancy in. No precedent, no principle. No principle because Article 4 is a first-order right, 4.1 is non-derogable, 4.2 is absolute, the qualifications delimit the right. The Secretary of State doesn't suggest fundamental breach or flagrancy where it would apply in a foreign case under Article 4, a Suring case. So why on earth should it apply where the acts occur here, a domestic case? No need for exceptionality either, contrary to what Sir James says. It will be the exceptional case we submit where removal will not risk frustrating the duty. Historical cases, my ladies, my lords, the purpose of the duty is to bring the perpetrators to justice. That purpose doesn't expire or diminish with time. It may be harder to discharge, but that is a question of fact. In terms of the duty, where the predicate is that an investigation is simply not possible, it's very dangerous to say that that is the case without trying, because the duty is one of means and not result. There needs to be clear evidence before the tribunal that it would be impossible to discharge the duty. You can't easily infer that from the fact that nothing's happened. We submit that in those circumstances where there truly is a historic case, and there's the clearest evidence is there that there was an insuperable barrier, or is now an insuperable barrier, to the effective investigation. And note that it's not simply criminal proceedings. We know that from cases like Amin. The point of this is to get to what happened. But in the extreme cases where there's no point whatsoever, there may not be a nexus with removal for the purposes of Article 4. But, as Mr. Coppell indicated, Article 8 would be in play to correct the historic injustice. That would be a relevant factor in the balance. And there is an authority on that in your supplementary volume, I'm afraid, supplementary to tab 69. It's the Gurung case, and it's paragraph 41 of Lord Dyson's judgment.
Sorry, paragraph?
41.
41, thank you.
Could a Gurkha show that his now adult child would, but for the historic injustice for which the Secretary of State was responsible, have accompanied him as a dependent child historically under 18? That was a strong reason for holding that it was now disproportionate not to permit the child to join his family, paragraph 41. There are other examples. Historic injustice, you've basically said as a matter of public law, that doesn't really apply in the TN case, the Rashid principle, but it's very much live in the context of Article 8. There are other cases which say that as well.
Sorry, could I have the reference again, please?
I'm so sorry, my lord. Gurung,
Yes.
volume, supplementary to
Thank
tab
you.
69,
Thank
paragraph 41.
Which is on page 214.
Thank you, my lady. I don't know if I've got any more time. If I haven't, I'm happy to stop.
No, you
there.
haven't. Sorry about that, Mr. Hussain, you don't.
I wanted to focus on those matters.
Yes.
I'll leave it there.
Thank you so much. Thank you. Sir James.
My ladies, my lords. The context here is an immigration appeal. There is, as you know, or there was, as you know, a right of appeal against the removal decision. Here, the decision in question was the 2nd of August 2013. Section 82, sub 1 of the 2002 Act, as then in force, provided for appeals against, quote, immigration decisions. And MS was an overstayer, so the decision in question was, quote, the decision that the person be removed from the UK. And the bases on which you could challenge that decision, Section 84 sub 1 of the 2002 Act as then in force, removal would be unlawful under Section 6 of the HRA, that's sub C of 84 sub 1, otherwise not in accordance with the law, that's the removal decision, otherwise not in accordance with the law, that's sub E of 84.1, or there would be a breach of the UK's obligations under the Refugee Convention, that's sub G. Those are the basic grounds on which you could challenge. There is no right of appeal under that scheme. There was no right of appeal under that scheme from a negative, reasonable, or indeed even conclusive grounds decision.
Well, that's not an immigration decision, is it?
It isn't an immigration decision, and so the route for challenge for that is judicial review. And there have been a number of judicial reviews, as you've seen from the authorities that have been put before you. And that is therefore the context in which this court has to consider the two key rafts of issues of principle, if I can characterise them in that way. The first is whether the ATC and all, or almost all, of its obligations have become part of the positive obligation under Article 4 of the ECHR, or whether there is still clear distinction between those two. And secondly, whatever the precise answer to that question, what are the limitations on what is relevant and therefore within the jurisdiction of tribunals considering appeals against removal decisions? So I turn first to the obligations imposed by Article 4, and the basic position under the Strasbourg jurisprudence we submit is simply stated. The obligations under Article 4 mirror those obligations developed under Articles 2 and 3 of the ECHR. And that development under Articles 2 and 3 has now got to the point where it is a very well-established basic taxonomy. So, just to identify them, they'll all be very familiar from the numerous cases you've considered under 2 and 3. First, there is a negative obligation. It applies under 2 and 3, it applies also under 4, mirroring it. The state cannot therefore itself hold people in slavery or servitude, or require them to perform forced or compulsory labour. That, mercifully, is an allegation rarely made against the state here, although I think it was raised in the Riley case about stacking shelves in supermarkets, if you recall the DWP case.
Yes, I wasn't in it, but I remember the case. Yeah.
That's the only one that I can remember where that negative obligation has been raised as an issue. But that's the first of the obligations that are created under these articles. Secondly, there is a positive duty on the state to have in place an administrative and legislative framework, so it's the framework obligation, designed to protect victims and provide effective deterrence against such activities, that is, holding people in slavery or servitude, forced or compulsory labour, by private citizens. That's why it's called a positive obligation. And that administrative and legislative framework obligation includes what in the Article 2 and 3 context is normally called the Menson duty, M-E-N-S-O-N duty, Menson in the UK. It includes a duty to have effective police investigations capable of leading to the prosecution of individuals for offences covering the Article 4 territory. And that was the basis of the finding of breach. It was the framework obligation that was an issue and was found to have been breached in Silly Adin and France. I don't invite you to turn it up for this purpose. It's Bundle 1, Tab 12, starts at MS 372, and the conclusion of the court was effectively that you needed in your domestic law a criminal law to penalise conduct covered by Article 4. And if your criminal law is not broad enough to do that, you run the risk of breaching the framework obligation. See, for that purpose, paragraphs 89, MS 400, and 112, MS 403. And that was the basis of breach in Saliadin in France. It was also the basis of breach in CN and the United Kingdom. See, for that purpose, paragraphs 74 to 77, Bundle 4, Tab 44, MS 1362. There held that the United Kingdom criminal law was not broad enough because it didn't correspond to include all of the ill treatment by a private individual of another private individual that would be covered by Article 4. And you have the same analysis in Rantsef and Russia. You've been taken to that segment of the judgment in Rantsef and Russia, so you know it well. It's 284 and following. That's basically the set of principles. All the obligations I'm now going through, they're set out seriatim in those paragraphs, which are then replicated in all subsequent Strasbourg case law on this, in this sphere. Rantsef is in Bundle 1, Tab 11, at page 295, the relevant paragraphs being 284 and following. But this framework duty was identified as a key part of it. It may just perhaps be worth turning that up to remind you, my learned friend Mr. Coppell took this relatively quickly, but if you go back to Bundle 1, Tab 11, if you would, and go to page 295, that's the first page. The relevant principled section in the judgment begins at MS 356. So paragraphs 284 and 285 are dealing effectively with the different aspects of that framework duty. So you need criminal law to punish the traffickers. You need a regulation of businesses often used as cover. And you need, in certain circumstances, immigration rules to address relevant concerns relating to encouragement, facilitation, or tolerance of trafficking. And it was on that basis that the Cypriot rules fell foul, because their whole system to deal with artiste visas, as they were called, were obviously inadequate for the purpose of providing protection for those who might come in and be being trafficked. And the whole of that framework has got to be designed to fulfil the three aims that Lord Lloyd-Jones drew attention to in 285, and we entirely agree with Mr. Coppell. They are prevent trafficking, protect victims, and punishing traffickers. It's the three that feature in the middle of para 285. And for this purpose, the ATC, the Anti-Trafficking Convention, if and to the extent that it has been incorporated into the domestic law of contracting states, and we know that it has here through the mechanisms Mr. Coppell correctly identified, can be part of that regulatory framework. The final thing to note about the framework obligation appears from paragraph 289 in Rantsef on MS 358, which is that it includes that framework, a duty in certain circumstances to cooperate internationally where appropriate. So MLA is an integral part of a proper and effective framework to protect. So that's the second of the obligations, and it's the first of the positive ones.
MLA means mutual legal assistance, doesn't it?
It does. It does, I'm sorry, I should have set it out, but it's international cooperation.
Written on our hearts, Sir James.
Yes.
We think about it every day, do we?
We
not?
do.
Yes.
Others may not, which is, I'm sure, why my lady hauled me up. The third of the duties is the positive duty to take, in certain circumstances, operational steps to protect against the sort of ill treatment which is prohibited by Articles 2 or 3 or 4. That's the obligation which is dealt with in paragraphs 286 and 287 of the Rantsef judgment, MS 357. And the language will be very, very familiar. And the reason it will be very, very familiar is because the language directly mirrors Osman. This is the Osman, or honor yildiz, if you will, duty. It's that duty. And the language is exactly the same. In the context of Article 2, as you know, where the obligation is to protect against one individual taking the life of another individual, that duty to take operational steps doesn't apply just whenever. It's triggered by circumstances in which the state knows or ought to have known of a real and immediate risk there to life. And it is breached if there is a failure to take reasonable steps conditioned by the realities of the difficulties of modern policing and all of that.
Actually, in 286, it's put a little bit more broadly than the way in which you've put it. May or may not make a material difference. Aware or ought to have been aware of circumstances giving rise to a credible suspicion that an identified individual had been or was at real and immediate risk of being trafficked or exploited. It's a little bit broader than the way you've put it, Sir James. But,
well, my lady, I'm perfectly content to take that, but that is reflective of the Osman situation.
it's reflective, but it's a little bit wider than what's said in Osman.
Well, they say what they say.
They say what they say,
It's credible suspicion at that point, but it's still aware or ought to have been aware of circumstances giving rise to that. And it's the credible suspicion that someone was or was at real and immediate risk of being subjected to the Article 4 ill treatment. So it is, I respectfully submit, substantially the same test and intended to be so. And that's why you have the direct replication of the take account of impossible and disproportionate burden language in 287. They're just transposing it into the Article 4 context. I should have added breach if there's a failure to take reasonable steps. You see that in the last 2 or 3 lines of 286. And it's then removing the individual from that situation of risk. And we know that in Article 2, there's a causative element as well that would realistically affect the outcome. So the same thing is being put. The key point, perhaps, to bear in mind in relation to 286 and 287 is that the aim and object of this operational duty is, quote, to remove, last line of 286, to remove the individual from that situation or risk. And the position in the Cypriot case that they were there dealing with was that the Cypriot police had been or ought to have been aware of the risk of trafficking to Miss Rantseva, made no inquiries, and critically sent her back to M, who was the exploiter. So that's the third of the duties. The fourth of the duties is the investigative obligation to investigate situations of potential trafficking and this duty is dealt with in Rantsef 288. And the analysis there identifies the twin aims of that investigative duty as applied in the Article 4 context. The first of them is to lead to a prosecution. So, as it were, that supports the framework duty in appropriate cases. And secondly, and more specifically, this is the point about urgency in the second half of 288, to remove an individual from a harmful situation where there is ongoing exploitation or ill treatment of that kind. So that supports, if you will, the Osman duty. So those are the four key duties that appear from the Strasbourg case law, and I respectfully submit that when you get to the general principle section of all the section judgments, and they're all section judgments, I don't think there's a Grand Chamber judgment amongst them, but that's the principle section, just basically repeats Rantzef. Those four obligations are cast in substantially the same form. And the first submission we therefore make is that these are well-established, clearly delineated obligations under Article 4 that essentially mirror and do not materially go beyond the obligations found in Articles 2 and 3. And it's entirely unsurprising that they do so, because the essence of the reasoning of the court is to place Article 4 on the same hierarchical pedestal as Articles 2 and 3. And it would therefore be surprising if there was a material distinction in terms of the obligations that were incorporated into those provisions. And as you know, most of these duties are as it were, implied into the articles. They're not express, they're put in by Strasbourg as the case law has developed. But the essential point is that they are designed to mirror. The second point is that, as Rantzef indicates, the Palermo Protocol, the ATC, and indeed sometimes other international instruments are indeed taken into account by the Strasbourg court. So my learned friends are both right to say that that is part of a standard process which the European Court regularly engages in, starting with the Grand Chamber decision in Demir and Turkey. It looks to the international legal position, not necessary for all parties to be signed up to all conventions relied upon. We agree with Mr. Hussain in relation to that. That's the reasoning of the court in Demir. But they look to it to see what the shape of the obligation should be under a particular article. The point is that they have done so and have arrived at these obligations, these four very well established obligations, directly mirroring Articles 2 and 3. There may also be specific instances in which they go back to the ATC for the purpose, for example, of reading over, as a matter of Demir type interpretation, the definition of trafficking and exploitation that you see in Rantzef at 286. And they do the same sort of thing when they return to that sort of issue in Chowdhury in Greece. And there the conclusion by reference to the ATC was that exploitation through work, there it was strawberry pickers as you will recall, the exploitation through work can also constitute an aspect of human trafficking. And they relied on the ATC for that purpose. My lady, that may be a convenient moment.
Looks like one. Thank you. We'll adjourn now and look forward to hearing from you further at 2 o'clock.